Hello, everyone. Welcome to the NCIEC webinar. Tonight's host is Chris Tester. Chris is an interpreter, a presenter, an educator, and a consultant. He is from New York. We're really looking forward to seeing what Chris has to share with us tonight. Next slide, please. I am Amy Williamson, and I'm Instructional Coordinator for the Marie Center. The Marie Center is one of the regional centers within the consortium. Next slide, please. The mission of the center is to provide technical assistance, education, and training. Tonight's webinar, we hope, will provide just that to our participants. Next slide, please. There are 5 regions within the consortium. The Marie Center is in Colorado. There are also one in Western Oregon. There is the Katy Center, which is in Minnesota. Gallaudet has a regional center. And there is the Northeastern, which is the Northern Regional Center, the Northeastern Regional Center, which also has located the National Center, which is the NCIEC. And that is the National Consortium of Interpreter Education Centers. And that is who is funding tonight's webinar. Chris, thank you so much for being here. We look forward to the information you have to share with us tonight.
Thank you, Amy. Hello and good evening, everyone. Thank you, Amy, for your wonderful introduction. As she said, I am Chris Tester, and this is my name sign. I'll give you a little bit about myself before we get into my actual presentation. You can see the title of my presentation on your screen. It is Identifying Hearing ASL-English Interpreters' Current Practice in Determining the Need of Deaf Interpreters for Court Proceedings. This is what my presentation will be on tonight. Next slide, please. Obviously, before we get started, I have to recognize several pivotal people to this presentation. I first have to recognize my master's program, which is the European Masters in Sign Language Interpreting Program, otherwise known as UMOSLI. My degree was actually confirmed from Heriot-Watt University, which is located in Scotland, and it's one of 3 universities that provides the education for the UMOSLI program. There's Heriot-Watt in Scotland, another university in Finland, and a 3rd university in Germany. Those 3 universities work in a consortium similar to the NCIEC and operate in a cohort-style manner. Each cohort is comprised of 21 to 22 students from all over the world. We actually had one from South Africa and myself from the States. And we met once every semester for 2 weeks and studied intensively together. But most of the program was completed independently through online studies. I had a wonderful experience in the program and really valued the education that I received. The program does specialize in international sign and English interpretation. We used international sign to have discussions about interpreting, And we chose to have those conversations in both International Sign and English. Because my research was based in a European master's program, sometimes you might see me sign some things in International Sign and it might not make sense. And that's because I used International Sign for 2 years and took a little departure from ASL. So you might notice some irregular signs this evening. I also have to recognize Jemina Napier and Hens Hessman. They were both my thesis advisors. And without them, I would not have made it through. So I must thank them for their support and encouragement throughout my entire tenure as a master's student. I graduated last summer. Well, actually, wait. Yeah, 2015. And I finished my master's degree in December of 2016. So I think that's everybody who I have to thank for contributing to this presentation and my master's thesis. Next slide, please. So before I could begin researching anything, I would have to identify a problem. Let me back up just a second. When thinking about what problem to research, I recognized that there was quite a few topics that I could have picked from, and I chose to pick how hearing interpreters identify when to bring in deaf interpreters in legal settings. And that's what my research really focused on. I also chose to function, or decided this because research on deaf interpreters and its role function in the court is very limited. And there is some explanation about what deaf interpreters do and what their role function is, but in terms of their role function in the court, it's very minimal. Most of that research focuses on hearing interpreters. The second problem is that in the United States, deaf and hearing co-interpreters are considered best practices in many situations within the courts. This has been well documented, and I will explain one document that made it very clear coming up in my presentation, and we'll talk about it. But the problem lies in that while that is the best practice, me, in my experience as a deaf interpreter, and in talking with other deaf interpreters, feel that hearing interpreters are really the front line in the courts. And it's their decision whether to or whether not to bring in a deaf interpreter into that situation, even though we've already agreed that deaf hearing co-interpreters should be the best practice. So those problems led me to thinking about what research I should actually do. I thought I could possibly focus on deaf interpreters and their role function in the court, but then I realized I would need to figure out how deaf interpreters actually arrived at the court, which led me back to hearing interpreters and their decision to bring deaf interpreters into the court. And I wanted to know why hearing interpreters decided to bring deaf interpreters into the court. And is it true that it's their full burden to actually make that call and make the decision? It might not be, but I thought that would be an interesting question to research. And that question, if answered, would lead to more discussion and possibly more deaf hearing co-interpreter teams. But in order for that to happen, you have to go all the way back to the beginning of why deaf interpreters arrive to the court. How do they get there? And one more point about my background related with this research is in the next couple of slides, you might notice that this PowerPoint was written for a European audience, meaning I might emphasize a lot of things that are related specifically to the United States and that you might think is commonplace, but I had to explain that to my European audience so that they could understand the frame in which my research was conducted. I'm also not including Canada in this. I'm only talking about the US legal system and interpreters' experience within the US legal system. Next slide, please. So, from the problems that I identified, I had to then come up with questions to answer. And go ahead and take a moment to read the questions yourself on the slide. So the goal of the study was to actually pinpoint the moment when hearing interpreters call for a deaf interpreter. My goal was twofold. The first was to identify what the decision-making process looked like on behalf of the hearing interpreter. What was that decision based on? What was the criteria that they were using to justify bringing in a deaf interpreter? And the second track was, were there any trends? Was there any specific point in time when hearing interpreters identified the need to bring in a deaf interpreter? I wanted to know what that timeline looked like. So those were the two questions that I tried to tackle within my research. So at the conclusion, you will see if I actually answered those two questions. Next slide, please. So part of my literature review involved looking at spoken language interpreters and research that's been done on them. And for me, it's really fascinating to look at spoken language interpreters and what their perspectives of interpreting in the legal system are. I really enjoyed that piece of my thesis because I'd been operating in a world of sign language interpretation. And there's actually a lot of research done with Spanish language spoken interpretation. And I think they bring a different perspective to the interpreting process that I really enjoyed learning about. The two main points with spoken language interpretation, and what I found in my literature review, was first, that there was a heavy focus on courtroom interpreting. Most of the body of research lied within that arena. There was less concerning law enforcement, lawyer-client meetings, government-related legal events. Most of the research focused on courtroom interpretation. And while there was some research, it's still a growing body. For example, there's a lot of research concerning medical spoken language interpretation, far more than there is legal spoken language interpretation. So there's still more work to be done. Now, when studying courtroom interpretation, there's many different facets that can be studied. And some of the themes that come out are the interpretation of witness testimony and the impact that has on the jury, or does it have an impact on the jury? How do they end up perceiving the witness? The interpretation process, was it done consecutively or simultaneously? The accuracy and fidelity of the interpretation. Those are the three themes that really come out in the spoken language interpretation research. And as you noticed, all of my slides have the citation where you can find all of the articles that I'm referencing. For example, Burke and Seligson focus on spoken language interpretation in witness testimony in legal systems. And some, like O'Barr of 1982, focuses on the language of the court. And many researchers use O'Barr and his article to discuss how the language of the court influences the interpreting process. There are a few articles that talk about how the interpreter tries to present the other person through themselves, tries to take on their persona. In spoken language interpretation, they usually say face, and so it's my face as the interpreter, and I'm trying to mask my own face throughout the interpreting process. And there's a lot of work and research that has been done into the power of the dynamic of the interpretation. The power dynamic that the interpreter has when they're interpreting in the court, depending on whether or not they take control or give up control. And again, that's a growing body of research. It's quite new, but they're actually examining the interpreter as a person rather than as just a conduit of language. And so that's another trend that's been coming up within the spoken language body of research. How does the interpreter themselves actually influence the courtroom interaction? And I'm sure if you have worked in legal settings before, you probably have noticed that the legal system is very regimented and uses a very structured language. And the court wants interpreters to follow that same structured language. The court is not willing to bend to the language of the people, but rather forces the people to bend to the language of the court. And when an interpreter is then placed in that situation, they're not just operating as a conduit or under a machine model, but rather they might have their own issues with the language and face difficulties in figuring out how to navigate the system. And spoken language researchers have started to look into this trend. And next slide, please, which will focus on sign language interpreting and the literature review done for my thesis. Take a moment to look it over. So there's three trends that I would like to discuss this evening. There are several big themes that came up during my literature review of sign language interpreting research. One was the perception of the role of the interpreter, and the second was the accuracy of the interpretation. These are the trends that are currently coming up in sign language interpreting research. You'll notice that it's a little bit different than the spoken language interpreting research, and I'm not sure exactly why, but I think within the sign language interpreting community and within the deaf community, we really focus on wanting to represent the deaf consumer well in the interpretation. And we focus on the identity and culture of the individuals within the interaction. And we want to make sure that the message is also accurate. Sometimes we're overly concerned with accuracy. And I think that could be why these themes emerged within the sign language interpreting research. So there's not much research on how we interact with the court, or how we interact with the judge or the people within the system. It's more on the identity and the accuracy of the interpretation. Under the second bullet point, there has been quite a lot of research done, and it's typically been on the impact of the interpretation mode on the accuracy of the message. So how does consecutive versus simultaneous interpreting impact the accuracy of the interpreted message? And there has been a lot of research done on the impact of the perception of the role of the interpreter, either the perception from the deaf consumer on the interpreter or from the legal system and their view of the interpreter. These are starting to trend, but there still hasn't been a lot of research done on these topics. There's also been research done on the interpreter's linguistic decisions, on why and how they are making the decisions to interpret things in a certain manner. And and there has been some research with video remote interpreting within the courtroom. Within the last 10 years, video remote interpreting has become more popular and has been used within the courtroom setting. And the third category that I included within my literature review, which I find to be quite relevant, is the deaf person's language. Do they have language issues or do they not? And the research that's come about from that question. Because depending on the deaf consumer's language, that impacts whether or not a deaf interpreter will be called to that courtroom setting. We know that certain populations have different linguistic skills. If we're thinking about the United States, what does our deaf population look like, and what, on average, are their linguistic skills? So that's been also a growing body of research. These three categories made up most of my literature review. Next slide, please. So as I mentioned, I wrote this thesis for a European audience, so I included this slide so that I could contextualize my study, because most of them would not be familiar with our US legal system. I didn't include these three pieces of legislation and or policies to their fullest degree within my literature review, but I did want to mention them so that they could have an idea and an explanation to why some of the results that I got. So the first one was the Federal Court Interpreting Act of 1978. The reason I included this is because it stated that an accommodation is not automatically granted. The individuals within the setting, the lawyers or the consumers, would have to request the accommodation. The law does not automatically grant or give them the accommodation, but rather must be requested. The second is the Americans with Disabilities Act, or the ADA, which outlined the statute for reasonable accommodations, but unfortunately that does not apply to the federal court system. It only applies to the state court system because the feds have been waived from the ADA. And often people don't realize that and can be confused, but the federal courts are separate from the state courts. So the federal courts follow the Federal Court Interpreting Act of 1978, and the state courts follow the laws outlined within the Americans with Disabilities Act. However, the Americans with Disabilities Act doesn't outline the expectations of providing the interpreter within the courtroom, just that an accommodation should be provided. And lastly, because we're located in the US, we have the Registry of Interpreters of the Deaf, who's our certifying body, and they have created their Specialty Certificate Legal, SCL. If you are granted the SCL, it means you're automatically professionally qualified as a federal court interpreter and can then interpret in those courts. It's important for us to know that once having the SCL, you are automatically granted access to interpret in the federal courts. So these three things are important to keep in the back of your mind, just to contextualize this study. I assume most people watching this webinar know about these three things already. But these rules and these laws do impact our work and how we relate to the system. Next slide, please. All research must have a framework to operate within. I chose two frameworks for my study. The first is the book that you can see a picture of. The title is Equality Before the Law: Deaf People's Access to Justice. And that was written by Mary Brennan and Richard Brown. The research that they did is phenomenal. It's a very in-depth look at the justice system in England and Scotland. So it's UK-based research, focusing on UK interpreters and their interactions with the UK legal system. Some of the issues that they outlined in the book don't really align to issues that we have here, but in my reading of the book, I found we did face very similar challenges and barriers. And this book provides three very different perspectives of the stakeholders. The first stakeholder is the sign language interpreter, the second is the deaf consumer, and the third is the legal system. The book includes law enforcement and courtroom interpretation in the study. So they interviewed hearing staff members of the court and of law enforcement. They interviewed deaf people who have navigated the system, either be it with law enforcement or with the courts, and interpreters. Mostly hearing interpreters. There was no deaf interpreters interviewed for their study. You'll notice that they published this book in 1997, so it's a little bit outdated, but at the time that they published it, the idea of a deaf-hearing co-interpreters had just been cropping up, but it was rarely employed. And the researchers were able to observe different situations in the courtroom, but they never had the opportunity to actually observe a deaf-hearing co-interpreter team, even though the interpreters reported that it had been used. There was one time that they were supposed to witness a deaf-hearing co-interpreter team, but the case was dismissed or dropped, so they didn't actually have the opportunity to comment on it. But it's nice to know that that idea was around in 1997, albeit it was a very new idea and the process hadn't been solidified for how to work together. So from my research, I actually pulled a lot of information from their studies on how they interacted with hearing interpreters. I used a lot of their questions and followed a lot of the same procedures, and they really helped inform my research. Some questions I directly pulled from their study so that I could replicate their study, or at least try my best to replicate their study. It's always nice when you can replicate a study and then draw comparisons. The book is actually out of print. The company who printed the book decided to take it out of publication. It was printed back in 1997. So if you would like to read it, I'm not exactly sure how you should find it. You can ask me or email me, and I might be able to ask some friends that might have a copy, or maybe see if it's in print somewhere or an old copy is available. So if you can get a copy of it, I would definitely suggest reading it. And also you can draw your own comparisons from what was written in 1997 and what the system is currently like in 2016. So that was the first framework that I used to ground my research. And the second framework comes from another book, which is called Deaf Interpreters in Court: An Accommodation That Is More Than Reasonable. And that was written by Carla Mathers, our legal expert interpreter here in the United States. And that book provides wonderful examples and insight into the world of deaf interpreters. It explains different statutes and precedents that have been set across the United States. Her research is also in conjunction with the National Association of the Deaf, who has done a lot of research on deaf individuals' language needs, challenges, and she incorporated a lot of that research into her own book. I would definitely read that book if I was you. It's only about 100 pages, and it offers a really great look into the world of deaf-hearing co-interpreters. There is one area of focus, which is deaf community members' language and the wide variety that we see in language used by deaf people in the United States. For example, if you are a French speaker, you might assume that French is more standardized, unless you're from a specific country that's not France. The language there is much more standardized than American Sign Language. American Sign Language within its own language has a lot of variation. For example, the reason being education, family. Do deaf individuals have a deaf family or hearing family members? Were individuals born here in the States, or did they immigrate from another country? There's a lot of different variables that can impact one's signing here in the United States, which in turn impacts the interpreter's ability to interpret, which in turn impacts the negotiation with the legal system. Because not only is an interpreter dealing with the deaf individual's unique language, but they're also dealing with non-standard English, the language of the court. Another area of discussion is that not all hearing interpreters have the SCL, Specialty Certificate Legal. So that means that there is a risk that the quality of the interpreter is not actually up to do the work of the courtroom. Another area of discussion is the burden of proof and the evidentiary burden with witness testimony, making sure that the interpretation is accurate, going from ASL into English. Those are the three main arguments and discussion points within the book. I briefly sum them up, but Carla Mathers goes into much more length. And I use the criteria that's outlined in Carla Mathers' book for how one identifies the need to bring in a deaf interpreter in my study. So I didn't create new labels or new reasons or new criteria. I simply duplicated what Carla Mathers had already published in her book. Same with the demographics of the hearing interpreters. I pulled those from Equality Before the Law because they had already established a framework of how to interview hearing interpreters. And I pulled the labels and the criteria for when to identify a deaf interpreter from Carla Mathers' book. So those two were the foundations for my research, and will give you a better idea of how I framed my study and will help inform the results as well. All research must have something to frame it. If you don't have a frame, your research often becomes too broad, complicated, and you actually don't return any results. Next slide, please. So, my methodology. I had a combined qualitative and quantitative approach. I used a questionnaire as well as interviews. So I used purposive sampling, but I did have requirements for who could take it. It had to be based in the US. They had to be hearing interpreters. No deaf interpreters were asked to take the survey. They had to have experience working in the courts. And just to be clear, I did not require participants to have the SCL, solely experience working in the courts. So I found these participants through RID's Legal Interpreter Member section, LIMS. I used their listserv. I also used Facebook. It's easy to post a survey and get it out to a lot of people. I also emailed specific colleagues who I know work in court settings. And that's an example of the snowballing effect, because I sent it out to interpreters who I knew worked in the courts, and I hoped that they would then forward it on to their colleagues who they know work in the courts. So that's how I was able to pull in the participants to my study. Next slide, please. One more. Should say questionnaire. So let me give you an idea of what the questionnaire looked like. I developed 29 questions, and I used Heriot-Watt University's online tool. It's called BOS. That's how my questionnaire was distributed. The first part of the questionnaire was simply demographic information. I wanted to know who the participants were. The second section in the questionnaire was based about their experience with the language of the court, plus legal training. And the third section, which is what I was really hoping to get at from my research, was their experience working with deaf hearing teams. I was really interested in deaf hearing teams, but of course they had experience working with hearing teams as well. And I wanted them to identify the criteria for calling in a deaf interpreter, and also what were the barriers in bringing in a deaf interpreter into a legal section. So that was the third part of my study. I will give you an idea of what some of my questions were in the upcoming slides. Next slide, please. I also did interviews. And in the interviews, I had follow-up questions that were based on the questionnaires that were filled out. Most of my questions were specific to comments and answers that they had made within the questionnaire. It was semi-structured. And as participants answered questions, I would ask follow-up questions to their comments. So that's why I call it semi-structured. I only interviewed people who had already taken the questionnaire. There was no individual interviewed that did not fill out the questionnaire. I interviewed participants through FaceTime or Skype. I also used QuickTime Movie Recorder to record the interview, and all of the interviews were conducted in American Sign Language. Next slide, please.
This is probably the most exciting portion of this webinar, which is the results and findings from my research. Next slide, please. I had a total of 78 participants. I did have 79 people respond. Unfortunately, one respondent was deaf. I wish I could have included the deaf perspective, and potentially for a second study, I would include that person, but this was focused on hearing interpreters. I'm going to let you take a look at the slide. I won't actually be going bullet point by bullet point on this particular slide, but go ahead and take a minute to take a look at some of the demographic information that appears on this slide. Hopefully that gave you enough time to read some of the demographic information. Next slide, please. There was a lot of data on that previous slide, but to sum up who the average participant was, they were female with over 20 years of experience. Most of the participants did have their SCL, and I would label them very experienced in the courtroom. The last point, which I thought was interesting, and I will add, is that most of the respondents said that they had greater confidence with their English skills than their American Sign Language skills. My question did not specifically relate to courtroom language or the language of the law, but just rate your English skills. And the question was, rate your American Sign Language skills in 1 to 6. Generally, people rated their English skills as excellent. With their American Sign Language skills, they rated it as good or great. So it was slightly lower than how they rated themselves for their English skills, which is an interesting point. And it's just something that we need to think about. Did that impact my data or not? There's not a lot of evidence to show that it did, but could it have skewed something because people felt that their English skills were far superior, or at least somewhat superior, to their American Sign Language skills? Next slide, please. I'm starting to show some of the questions and answers from the respondents. The first question was, I have difficulty in understanding the deaf client. That was number 16 out of my questionnaire. Most participants, 44 of them, responded rarely. 34 participants responded with sometimes. And this was the majority of the number of people. So rarely and sometimes were most answered. Now the next question I asked, if you answered rarely, can you rank the following from 1 to 6 in why you would have difficulty? So there are 6 choices that you can see there. The first is that the deaf person had underdeveloped American Sign Language skills. Perhaps they had a cognitive challenge. Was it because the person was foreign born and used another sign language other than ASL? Was it because they had limited English or limited education? And the 6th was other, so an answer other than the previous ones. If they answered other, they had to respond in the comment section of what they meant by other. By far, the top answer was number 1, that the deaf person had underdeveloped ASL skills. I was not surprised. I did expect that result. I think that that matched what Carla Mather's research had already shown. And based on my own experience as a deaf interpreter, that is what I both have seen and discussed with my colleagues, that the challenge is often the language used by the deaf consumer. So I'm not surprised by that result. Next slide, please. I asked the participants their rationale for requesting a deaf interpreter, and I gave them a list of labels. Remember, this was based on the framework from Carla Mather's book. These labels were also from Equality Before the Law. So I incorporated both Carla Mather's book and Mary Brennan's book and put them together in this question. I gave the participants 8 choices, and I'll let you go ahead and take a look at what those choices were. if you notice number 2, it says the deaf individuals ASL. I wanted people to use the criteria that they had just seen in question number 17, where I was talking about the cognitive challenge or the underdeveloped ASL skill. So based on that, you would pick number 2, which is the deaf individuals ASL skill. So this was just the next question, so it related back to that. It saved me the time of having to talk about and explain to the participants what I meant by deaf individuals ASL. The results are on the next slide. Next slide, please. We may have gone one too far. Can we just go back one slide? It should say results. Oh, that's fine. First, and the most obvious, if you only counted the number 1 reason why the participant would ask, is the deaf person's ASL, and that's why a hearing interpreter would call a deaf interpreter. Once again, I wasn't surprised by this particular result. I expected that. What I decided was to relook at some of the data to see if we could interpret it in a different way if we categorize the numbers differently. So we gave them 8 choices. So I allowed to choose the top 4 from each participant, and I categorized those. The second most popular choice, if you looked at what people chose from 1 to 4, was that it was a complicated situation. So if you allowed people, if you incorporated what people responded with from 1 to 4, you saw that complicated situation with 71 responses, and in deaf individuals ASL was 74 responses. Now, that's pretty close. Now, if you're only going to look at number 1, deaf individuals ASL it was very obvious that it was the first. However, if you looked at the data slightly differently and looked at top choices, not just the top choice that someone might choose to have a deaf interpreter, complicated situation was very much up there. And I'm going to show you a quote of what one participant described as a complicated situation. Next slide, please. I'll allow you some time to read that. I thought this quote represented what a complicated situation could be. There are so many possible factors that could impact the language and the interaction that the deaf person has with the court system. The system itself is very scary. It's difficult to understand for the deaf person going through the court system, and that can influence their language. How the interpreter chooses to communicate between the deaf person and the court system is not just about the deaf person, but it's about mediating the relationship that this person has with the court system. And it could possibly be not a positive situation, right? It's a negative situation. And so that can certainly impact the interpreting process. Next slide, please. The next question I asked was, how often do you work with a deaf interpreter team? If you can see the bar graph, what you'll notice is that sometimes was answered the most, and that was 35 respondents, which came out to about 44–45%. So sometimes was ranked number 1. So the interesting thing was, what does the participant view as sometimes? What is their perspective on what sometimes means? And it's hard to have a concrete number because if that interpreter works, let's say, once a month in the court, that means they work 12 times in the court. So if they have a deaf interpreting team 2 times, that sometimes. But you may have another interpreter who works weekly in the courts, which means that their sometimes might mean once a month or even twice a month. So it's hard to force a number. How often do you work with a deaf interpreter in terms of getting a raw number, because it depends on how often the participant works in the courts. It would require a longitudinal study, and that's something that I will mention later in this webinar. It would require a different approach for the research that was done, and that's not an opportunity that I had at an MA level. Next slide, please. So first I asked how often, and now I asked how often do you request to work with a deaf interpreter? These results were interesting because the #1 response was often. Approximately, 33, which is approximately about 42% of the respondents requested a deaf interpreter often. And I thought that was interesting because hearing interpreters mentioned that they worked sometimes with deaf interpreters, but it seems as though they're requesting them often. That doesn't add up. And if you notice, 2 respondents said never. They never request a deaf interpreter. I guess they were being honest in my study that they never asked for a deaf interpreter. I appreciate the honesty. Next slide, please. This particular quote is a good quote from one of the interpreters about their process on whether or not to go ahead with interpreting or to stop the proceedings and ask for a deaf interpreter. I'll allow you some time to read this particular quote. I have shown this quote several times in different workshops. In the spring, I presented at TCS's Legal Summit in Washington, D.C. Now, this legal summit was for deaf interpreters who worked in the courtroom, and I showed this quote. From the deaf interpreter's perspective, they were very divided on how they felt about what this interpreter did. Some felt that they fully supported this hearing interpreter. It must have been a very stressful situation, that the interpreter's burden of having to decide, I get to decide whether this person stays for the weekend or not, was extremely burdensome, and they felt for the hearing interpreter. However, half of the deaf interpreters did not feel that way. They felt it was very dangerous. Do you know whether the deaf consumer really understood? Because would they know that they would have to go to jail anyway? And maybe that by sending this person home, that they would be further misunderstanding what was going on in the court system. So there seemed to be a real conflict in that particular setting where I presented this quote, because some people really empathized with the hearing interpreter in her decision making for proceeding with the court, and others did not. So I'm giving you my opinion about this as an interpreter, wearing my interpreting hat, not my researcher hat. Different states have different limitations and different resources. But one thought I had is that for an arraignment, could we automatically send a deaf hearing team so that a hearing interpreter would never be put into that situation to begin with? Because a hearing interpreter feels that burden once they're already, the wheels are turning and the system is already in place, that they have to resolve it. But you could be proactive in that way so that a deaf hearing team always works for arraignments. I mean, it's just something to consider to alleviate situations as like that. Next slide, please. So this next question addresses how often someone else, other than you, the hearing interpreter, asks for a deaf interpreter. And it might seem on its face to be an interesting or strange question. How often does someone else ask for a deaf interpreter when we know that hearing interpreters are often the ones that ask? But as an example, I work in the state of New Jersey, and the system is already in place that if that deaf person has already been at some point in the system and they are, for lack of a better word, flagged to have a deaf interpreter, you will have that person, you will have that deaf interpreter on the ready. So the hearing interpreter doesn't necessarily have to ask for that in future proceedings. So that's one of the reasons why I asked this question. And I'm not surprised by the results. Most people responded with rarely. There were 30 participants who responded with rarely, which was about 38% of the respondents. So rarely does someone else put a deaf interpreter in place for the hearing interpreter. I was surprised that never was so high at 14 participants. So those 14 participants always have the burden, if you will, of asking for a deaf interpreter. And why is that? They might be the only hearing interpreter that works in the court system. Do they think that their peers have a different perspective? I'm not sure, but I thought that response never was higher than I would have expected. Next slide, please. I interviewed 3 participants. They said that they always considered deaf interpreters when they were working in the courts. Always. I'm not sure how it proceeded in terms of how they requested or not requested a deaf interpreter, but it was always part of their thinking, no matter what assignment they had. Next slide, please. I decided to ask hearing interpreters their experience when they were not working with a deaf interpreter and they were working in the courts. How often did they proceed and felt they managed okay, but it would have been better with a deaf interpreter? The highest percentage was 59% who responded as sometimes. They felt that, yeah, they managed okay, but it would have been better if they had a deaf interpreter. They still continued anyway, and sometimes that happened to them. So it seems most of the participants that I surveyed felt that at least some of the time they would have had a better situation if a deaf interpreter had been there. Next slide, please. I wanted to know what were the barriers or issues that prevented deaf interpreters from being provided. I wasn't trying to blame the hearing interpreters for not providing deaf interpreters. I know that there are barriers and issues where hearing interpreters may try, but they are thwarted, and therefore I knew that there must have been some barriers. I was interested in finding out what those were. I gave them 7 options. Well, I gave them 6 options, and they could have chosen other if they didn't feel that that met what they felt. Some people said, I communicated fine, and I just decided to proceed. Did the judge decline your request? Or did the lawyer object to the request for a deaf interpreter? Was the interpreter coordinator not able to find a deaf interpreter? Did the deaf client refuse a deaf interpreter? Did you ask for the deaf interpreter for next time because you didn't want to stop in the middle of the court proceedings? If they chose 7, which was other, they had to explain what this other reason was. These results, I have to tell you, were quite surprising to me. The number one reason for the barrier to a deaf interpreter was that they could not find a deaf interpreter. I really thought we'd see a higher percentage for that the judge declined the request. I think this is an important point for us to recognize that what about deaf interpreters? Our biggest barrier is that perhaps there are not enough deaf interpreters. Well, let me rephrase that and say there are not enough qualified deaf interpreters because, of course, we're looking for qualified deaf interpreters to work in the courts. So is this the actual barrier to getting deaf interpreters in the courts? I find this interesting. As a teacher, I have given trainings on how to talk to the judge, how to convince them by using strong language when we talk to the courts for bringing in a deaf interpreter. We felt that this would help hearing interpreters who find the phrasing of it awkward or don't really know how to approach the court. But my data did not support the need for this because it does seem that judges aren't the problem. Look, I'm not saying judges are never the problem, but it does seem that interpreters think that the barrier is that there are just not enough deaf interpreters, and I found that to be very interesting. I did also have one more interesting finding. And this is something that comes up a lot, which I will show you in my next slide, please. Maybe some of you recognize this experience. I'm not sure. But if there are other interpreters, SCLs, you know that they would proceed with this particular court case to cover this case without a CDI. So the precedent has already been set, and we feel like we can't go back. So this might be a problem that the hearing interpreter feels like, well, this will be it. They'll blame me that my skills are not up to par, and this is why I need to request a deaf interpreter because my colleagues have been working with this particular client and never requested a CDI before. Again, look, we're still talking about the burden that is placed on hearing interpreters to defend oneself for the need to have a deaf interpreter. This idea that we need strong language and be able to argue our case, if you will. So that means that as colleagues, we don't have a standard approach. There's no specific expectation, really, for working in the courts, depending on how we've been trained or what trainings that we've had. Related with this quote is 2 important researchers. Sandra Hale and Deborah Russell. Those 2 researchers are the main researchers for sign language interpreting in the courts. Sandra Hale specifically researches spoken language, while Deborah Russell researches sign language interpreters. There are a few others, but these are the main researchers in this field. And one of the things that they found is that there's not a consistent practice that interpreters have for the approach to the work that they do in the legal setting. the training that is done for interpreters is different for each individual interpreter. We find this also, this corollary with spoken language interpreters. And I think that supports the finding of other research is that there's not a systemic way of how we do our work and what the expectations are for interpreters in the courtroom and for ourselves in the courtroom. I think that's an important point for our consideration, because as we move forward and as we continue this discussion, this professional discussion in our field, one thing that I've considered a lot as an interpreter and a researcher is that we often focus on our personal needs as the interpreter. Of course, that's natural, right? I'm working today. I have to figure out what I need in terms of the communication for today. Am I a good fit for this particular situation in this moment? We're thinking about today. And I can include myself as a deaf interpreter in this situation. But we're not necessarily always thinking about future cases. Will my decisions today in the moment impact future decisions on future interpreters? So will there be another interpreter in this in the future proceedings for this particular case? It might be me, but it might not be me. So we forget to look at maybe the case or the situation as a whole. We need to look at cases from beginning to end and not necessarily this hearing, this proceeding today. That's something that we need to consider, and it has a great impact on our work. Next slide, please. Some conclusions from my research. First, more than 50% of the participants had over 20 years of experience working in the courts. In addition, over 50% had their SCL. So this was the pool of participants that I had in my study. Deaf consumers' underdeveloped ASL skills were the main criteria for bringing in and requesting a deaf interpreter. That was clearly answered in my research. The majority of my participants, or the participants in the study, have worked in a deaf hearing team and support the idea. Maybe you got a sense from data that there were 2 people, as I mentioned, who said they never call a deaf interpreter. I mean, I'm thrilled that I had some people who answered that way, because we need different perspectives. We don't always want to draw on people who necessarily support the idea of working with deaf interpreters. If there are hearing interpreters working in the courts and don't think it's best practices, we need to hear from them. We need their honest feedback, and we need to include them in the research that we do. I'll talk a little bit about why I'm grateful for that particular perspective when I talk about the bias of my research in the next slide. But moving down to number 4. Based on this data, unfortunately, I couldn't conclude precisely when the interpreter decides to bring in a deaf interpreter. That timeline was not answered in my research. The 5th conclusion was, this was based on a lot of the comments that I received, because I did have 2 open-ended questions where I asked for comments from the participants. It seems that most hearing interpreters prefer to have statutory support to identifying when a situation requires a deaf interpreter. They wanted, if you will, a more black and white policy on when to bring in a deaf interpreter. When is it appropriate to bring in a deaf interpreter, as opposed to relying on their own personal decision-making to make that call. I think that's really important, that interpreters are looking for a systemic way to make those decisions, as opposed to making them on a very individual basis. They want a system in place that so that they can focus on the work and not necessarily all of the ancillary things that come with that request, like negotiating with the judge or finding someone to get a deaf interpreter. When I say statutory support, I work in the state of New Jersey, as I've mentioned. It is written into the law that they recognize that a hearing interpreter at any point in a proceeding can pause the proceedings and request a deaf interpreter. In the statute, it's called an intermediary interpreter, but the point is that it's a deaf interpreter. The judge cannot challenge the hearing interpreter if they know how to use the law correctly and the statute correctly. The interpreter can identify that they have the right, and the judge has to abide by that. So that's very powerful to have that statute behind you when requesting a deaf interpreter. Next slide, please. The limitations of my study. There were 3. Of course, researcher bias. I'm deaf. I am a deaf interpreter. I also am a legal interpreting educator, and that has a huge impact on the community. I teach legal interpreting, which means I'm most likely drawing people who favor me, and I'm less likely to draw in people who disagree with my point of view, whether it is that they don't want to insult me or they feel intimidated by me, so that they may have ignored my research. And that unfortunately meant that those people were not involved in my study because I would have liked to have people who disagreed with my approach. So that's unfortunate, and I recognize that there was potential bias as a deaf researcher / deaf interpreter in this particular study. Second, I used purposive sampling, which certainly limits the sampling. We were looking only at legal interpreters. While it's a good idea to broaden your research, with purposive sampling, you're of course going to draw in more interpreters with their SCL. Interpreters who do not have their SCL felt that perhaps they didn't consider themselves legal interpreters, even though most definitely they had worked in the courts. And third is the fact that we used a questionnaire. So this particular format limits how people can respond, which therefore limits how much information you can get from the answer. So if you're curious about an answer, you can't go further and dig deeper. Next slide, please. I do have recommendations for future research. First, I would love to expand on the interviews that I did and include more participants in those interviews. I think you can get more specific. About their decision-making process. And we can look at when was that trigger point that they realized I must have a deaf interpreter. Was it when they accepted the job? In the middle of the proceedings? When typically is that point where they recognize the need for a deaf interpreter? My second recommendation would be to conduct a longitudinal study. It would be good to track interpreters and their experiences. We would ask them to document what the trigger was when they realized they needed a deaf interpreter in the courtroom, and what criteria they used for selecting a deaf interpreter. How they resolved that problem. Third, we could replicate this study that I just did using deaf interpreters. We could look at interpreters' training and background and find out some of the demographic information and get some more data, which we desperately need. We could model Brennan and Brown's book, Equality Before the Law, that I mentioned, and include more stakeholders. so we have hearing interpreters' perspective, but we need deaf consumers and deaf interpreters' perspective. We also need the hearing staff who work in the court system. So we could include the gamut of stakeholders in a bigger study. I encourage anyone who's interested in doing some research to expand on the research that I have done, because I think it would be terrific to see more work on deaf hearing teams. We need more work on the process of what it looks like in the courts. We need more information on the training or the knowledge. We also need more work on what the actual interpreting process looks like between deaf and hearing interpreters. How do deaf and hearing teams work together in the court system? We certainly need more research on that. So I encourage anyone who's taking this webinar to look at the research that I've done today and expand on it, because we need more information. I know perhaps not in 2016, but in the future, we need this research. I really thank you for your time. The following slides are references where I received a lot of my, where I got a lot of my data. They're certainly worth a look. Thank you for your time. I really appreciate your interest in my data. And Amy, I will turn this over to you.
Thank you so much, Chris. I really appreciate your last point about needing more research in the field. And hopefully somebody could replicate your study, just like you said. I think that would be an extremely valuable gift to the field. So thank you so much for your contribution and sharing your knowledge with all of us. You've definitely left us with more questions than we have answers for, and suggestions for further research regarding how interpreters work within the legal system. Thank you all for joining us, and next slide, please. And actually maybe a few more slides. Yep, there's a few references. Here we go. So of course, I would like to thank Carrie Woodruff for all of the technical support, and also to the interpreters, Dylan Guile and Debbie Olson. Thank you so much for your time. Obviously, we couldn't have done this without you. Next slide, please. Tonight's webinar will be archived and then uploaded to our website, and you can find it at interpretereducation.org. There is also a ton of information housed within this website, so please do take a look at it. And next slide, please. Of course, our funding for tonight's webinar was funded from the U.S. Department of Education and the Rehab Services Administration. Good night, and again, thank you, Chris.